All right, good afternoon and welcome, folks. My name is Marissa Bluestein. I'm an assistant director at the Quattrone Center for the Fair Administration of Justice at the University of Pennsylvania Carey Law School here in Philadelphia. We are a technical and training assistance provider for BJA to grantees under the Upholding the Rule of Law Preventing Wrongful Convictions programs. But we host these monthly trainings on post-conviction matters, really for anybody in the country who is involved in this work and trying to produce and give information on topics that are relevant to the work that y'all are doing. So this month we are going to be focusing in on keeping agreements on track, how to ensure that victims' rights are being protected throughout the post-conviction process. And I have invited Guy D'Andrea, who is a partner at a firm here in Philadelphia, to help us with this, as well as Val Newman, who is familiar to a lot of you as the director of the Wayne County Prosecutor's Office. And I'm going to introduce them in just a minute, but I wanted to give a bit of background first about why we're having this, why this topic, and what we hope to accomplish. Not starting today, may not likely finish today, but we want to start today. So, as many of you may be aware, there have been cases in the country that have had an agreement upon an outcome between a prosecutor's office and defense counsel, innocence lawyer. And those agreements have not gone forward or not been accepted by the court because of either intervention from the crime victims, from the original crime victims, but usually over an assertion that their rights have not been protected. So what we really are looking to do here is not kind of have everybody retreat to the corners and come out fighting, but really looking to create resources for prosecutors and defense counsel in post-conviction settings so we can prevent those kinds of mistakes from happening moving forward and hopefully keeping agreements on track. So I realize that we have covered victims' rights before, and I will put some resources in the chat in a bit from our friends at Healing Justice, which is an organization that works directly with crime victims in post-conviction settings and has a whole toolkit for lawyers engaged in post-conviction work to try to work with victims through this process. This focus is a little bit different, is really trying to ensure that victims' rights are being protected and acknowledged, and so that they be heard through that process and hopefully keep agreements on track without getting kind of derailed. So what really brought this about was a case that came out of Maryland, which I'm sure is familiar to most of you, which is the Adnan Syed case, which came out of the Maryland Supreme Court. So what had happened in that case, and I know there are folks on the call who have either been directly involved or more informed about the case than I, and if I make a mistake, please unmute and correct what I say. But there had been an agreement reached between the prosecutor and Mr. Syed's defense counsel that the conviction that he had been serving should be overturned because of information that had been discovered in the post-conviction setting. The hearing, as I understand, was set for a Monday. The victim's family says that they were only notified on a Friday by email, and because they were in California, they could not attend the hearing in person, although they wanted to. There was an attorney who appeared at the hearing on Monday representing the victim's family and representing to the court that they wanted to be present, they wanted to be heard, and the court didn't allow that to happen, but did allow the victim's family to be heard through Zoom, and they were attending it on Zoom, but did not continue it so that they could be heard in person. So that got appealed through the state system up to the Maryland Supreme Court on that question in terms of what rights the victim had to participate in the hearing, what that participation meant, and whether the case should be reversed and remanded so that the victims could participate. And that is exactly what the outcome was. The Maryland Supreme Court reversed the outcome from the trial court, remanded it back to the trial court, so not just so that the victims could be heard through a victim impact statement, but so they could be heard on the merits of the case, which is somewhat unique. And I will just kind of go through a little bit about that decision so we have kind of a common ground that we're working on. So in Maryland, victims do have a right to attend, they say, any proceeding in which the defendant has a right to appear, and that in sentencing or disposition cases,
That's not Georgia, though, right?
the victims has the right to be heard at a hearing, as they define in the statute, as an alteration of a sentence or disposition. So what the victim's family had asked for was that, based on the fact that the hearing had a potentially dispositive outcome, that they wished to both be physically present at the hearing and meaningfully participate and be heard. And they were arguing under that statute that that was essentially what was intended by the legislature when passing a statute that says that they have a right to attend. It would be meaningless, according to the victim's family, if they didn't also have the right to be heard. Ultimately, the Supreme Court agreed. What they said was under the statute, that the statute, the way it was worded, suggested that the General Assembly contemplated that victims would have a right to be heard at a sentencing or dispositive hearing, but also not just as a victim impact statement from which we're all familiar, but as they said, also as to legal issues, including but not limited to the type and length of sentence the victim believes the court should impose. That was a fairly broad interpretation, most people will say, of the statute by the Supreme Court. And so what we're left with in Maryland, at least in this particular case, was that the victim's right to be heard at the hearing, vacatur hearing, includes the right to address the merits of the vacatur motion. And the court went on to say that because the parties here were not in an adversarial posture on the issue before the court, neither the state nor Mr. Syed was well positioned to present a contrary position to assist the circuit court in analyzing the vacatur issue. By presenting adversarial positions in these sorts of cases, victims and their counsel can aid the judicial fact-finding and decision-making process. Obviously, that decision could have wide-ranging impact upon pretty much everybody on this call doing this type of work. And so what we really wanted to try to do was start to work on a resource for people so that we could be aware of what the victims' rights are, how they can be protected, and to try to, as I say, keep these kind of agreements on track. And so to do that, I invited Guy D'Andrea and Val Newman here. And I'm going to ask you both to unmute and put yourselves on camera for us while I introduce you both. So Guy D'Andrea is a partner in the Laffey, Bucci, D'Andrea, Rich, and Ryan law firm based here in Philadelphia. He's focused his career on helping victims and working with victims, not just in the criminal setting, but also in civil settings as well. But Guy's background is as a prosecutor. He was a prosecutor in the Philadelphia District Attorney's Office, as I remember correctly, in the Family Violence Unit, as well as in the Homicide Unit there. He is also an adjunct professor at Drexel University, Thomas R. Klein School of Law, in advocacy and in technology in the courtroom, and is a member of the National Crime Victim Bar Association, which is kind of how I tracked him down. Val Newman, as many of you know, is the director of the Wayne County Conviction Integrity Unit. Before taking on that role, she was a defense counsel for over 23 years with the State Appellate Defender Office, with a very storied career. Since she's been at the Conviction Integrity Unit, she's worked particularly to try to keep victims apprised of situations and aware of a case outcome to prevent exactly what happened in Maryland from happening, and so far has been very successful in that outcome. So I want to welcome both Guy and Val to being with us today. And there you are, Guy, there you are. Let me just put you up here for everybody to see more easily. There we go. And Val is here too. So Guy, thank you so much for being with us. Very happy to have you with us, of course.
Thank you for having me. I'm happy to be here.
And Val, as always, just so grateful to you for sharing your time with us. So what we're hoping to do, we're going to have a conversation about some of these best practice issues that we're hoping that folks are already thinking about. And if we have time, we're thinking to break into 3 different breakout sessions to try to start developing and thinking about developing resources and best practices, particularly for prosecutors who are involved in post-conviction, to ensure that victims' rights are being protected. And so we aren't getting kind of cases taken off a desired outcome. So Guy, I'm going to start with you. First of all, did I get anything wrong in your introduction? And if so, please correct that.
So I was never technically assigned to the Family Violence Sexual Assault Unit, but I was in what Philadelphia called B Court, which is where I represented the Commonwealth against alleged individuals who had sexually perpetrated against children.
Thank you. So I appreciate that. So thank you.
I mean, yeah. So in that vein, yes.
Appreciated. So Guy, I want to start with you, and let me take down the cover slide. So what rights do crime victims have in a post-conviction hearing generally? Understanding that there's differentiation among the states, but in a general sense, what rights do they have, and how are victims, and how do you help victims ensure that those rights are being protected?
Absolutely. And Marissa, again, thank you for having me. I'm happy to be here. And you're absolutely correct. There are many different iterations of, a victim's bill of rights, so to speak, across this country. Some have more teeth than others, right? And so in terms of federal court or some other jurisdictions that have a lot of teeth to their statute, if a victim or the victim's family, in the case of a homicide, is not fully apprised, doesn't have a voice in the procedure or the process, whether it's ultimately the voice that is heard the loudest, that's not the point. The point is, in most jurisdictions, the victim needs to have a voice in the process. Sometimes it looks very different depending on how the conversation goes with the victim, but if they don't, many circumstances or many times, if there is an outcome that has been reached fairly justly and based upon evidence or lack thereof or conduct that was committed, and you haven't done that what I call a basic step of notifying the victim and allowing or at least inviting the participation in some capacity, all the work that you may have gone into or went into analyzing a case for post-conviction relief and coming to, again, if it's a just decision can be overturned, undone, or delayed for a lengthy period of time simply because you did not afford the victim the opportunity to be heard. It's really that simplistic. I mean, so if the work that's being done is with an eye towards justice and wanting to have the right outcome, it shouldn't be completely unraveled or undone because a very simple, in my mind, and basic step was overlooked or not done appropriately.
Okay, and just keeping on that question, so you said they have a right to be heard. What does that usually mean? And how, and is that in person? Is that online? Like, what should prosecutors in particular kind of have in mind when trying to make sure that they are they're abiding by those rights and what they're required to do?
Sure. So I think there's a dichotomy between what does your jurisdiction require and what is a best practice, right? And so a lot of jurisdictions will require, not a lot, but enough jurisdictions require that the victim be afforded the opportunity to be heard. That could be in writing, meaning the prosecutor or someone else reads the wishes of the victim or the victim's family. It could be that the victim comes live and testifies. It could take the form of a notification by the prosecutor that, listen, the victim or the victim's family doesn't want to say anything, right? They have, I don't mean to put this flippantly, but they have moved on. They have tried to heal from this, especially if it was a historical crime in nature, right? Meaning 20 plus years ago, or magic number to it. But, so it can take the form of, here's what we've done to bring the victim in or the victim's family in, and here's the response we have been given, right? And so there are jurisdictions that require at least those attempts. What I think is the best practice is to assure that a future court or a future potential law change, when you're going before legislatures or if a Supreme Court is weighing in on it, if you're already doing it, meaning if your jurisdiction doesn't require in post-conviction a victim to say anything, right? I still think it's a best practice, meaning if a prosecutor and a defense come together and say, look, we've reviewed this evidence and based upon reasons X, Y, Z, A, B, C, whatever it may be, this is the just outcome, even if the victim disagrees with that, and for either emotional, personal, or other reasons, why not present that to the court? Listen, Your Honor, here's the position that the prosecution and the defense have taken, and here's why. I'll also note, though, Your Honor, that we did speak with the victim or have the victim there, and this is their position. But, despite that, here's the law, here's the evidence, here's what happened, but we wanted Your Honor to have a full package. I don't know that anyone would be able to challenge the fairness, so to speak, if you take that step. And I say this, if you are actually doing the right thing, in other words, the evidence you have, the law you have, the facts as you know them, unequivocally support that a defendant or a convicted individual needs a new trial, should be exonerated, or anything in between, if you're doing the right thing and for the right reason without untoward or political motives, then it shouldn't. I don't mean this how it sounds. It shouldn't matter, right? Whether the victim wants or doesn't want that outcome. Of course, it matters to them as a family unit or a person. I don't mean it like that. What I mean is, if you're truly doing the right thing, you should have no problem with the victim being there, regardless of what the victim or the victim's family is going to say.
Fair. And Val, to change just a little bit, so coming into your position as the director, from being a defense lawyer, with your career, how did you educate yourself on these issues, particularly on the rights of victims, and what steps did you take as an incoming director to make sure that you were abiding by those and protecting those rights? And if I also got anything wrong in your bio, please fix it. But
so that's a great question. And coming in as a defense attorney, and I think many of the CIU directors come from the defense world. We're just not used to dealing with victim issues. That's something the prosecution has always dealt with. We come as defense attorneys, we do our job, and all of that is dealt with on the other side. So it was something that was very, very new to me. We have a very robust victim rights legislation here in Michigan. So the first thing I did is just familiarize myself with what's required. And I would encourage everyone to do that. It's not necessarily, I will say as a defense attorney, that was not top of mind for me. That was not something that I was, I don't want to say I wasn't concerned, but I just wasn't really thinking about it because I wasn't in tune with it when I first started. And so I remember my very first case, I went to the home of the victims. It was a murder case. And the mother of the murdered gentleman was willing to meet with me, as was the sister, but the father wanted nothing to do with us. So he was in the house, but, stayed away. And it wound up being a very good experience because they did not want an innocent person sitting in prison for the murder of their loved one. And we were lucky enough in that case that we were able to solve it. So I think those are kind of the easy cases to meet with the victim's family, because not only can you say, have a robust explanation for what you did, why you did it, why the office is agreeing to relief, but if you can give them some of that closure, that not only were we able to show that this is not the person who did it, but this is the person who did do it. And oftentimes I have found that person is deceased or already in prison serving a very lengthy criminal sentence. So you're not going to retry the case, but you can explain that and they can take some comfort of why you're taking the actions that you're taking. So that's the first thing I would say to people is just read the statutes. If there is a statute and or court rule, find them, read them, and be super familiar with them. The other thing is don't be afraid of this. It's, on some level, you're coming at this, that there's an injustice been done. There's an innocent person who's sitting in prison, and maybe really nothing else should matter except moving very quickly to get that person out of prison. And there's no, I'm going to be like Guy. I don't take this the wrong way when I say there's no rush. Of course, any minute, any second that an innocent person is in prison is a horrible second, a horrible minute, a horrible day. But doing things right has to be paramount. And doing things right means engaging the victims. I see that Chris asked a question, what is the time when the victim should be notified? I think that's case by case. We have a lot of cases where we want to talk. We do a lot of, I'm sure like most people, a lot of our cases are homicide cases. And a lot of times we want to talk to the victim's family because we think they might have information. So those notifications are going to be done very early on that we are looking into this case. I have a case right now that I just presented to the prosecutor, and it's a pretty violent sexual assault. And I'm not going to notify that person unless the prosecutor is going to grant relief. I don't want to reopen that wound from a 25-year-old crime. Unless the prosecutor is going to say, yes, I think this office should agree to relief, in which case, then we would do the victim notification, and we would do it in a way that gives that victim time to process. I'm not going to notify her and say, the prosecutor's already decided to relief and we're going to be in court next week. I'm going to, those are very difficult notifications because someone has been, they've lived with that trauma for a long time, and reopening this can be very difficult. And so just have to explain to the defense attorney that we need the time to work with the victim.
Right.
And so you give the victim some agency. And I know this is a big issue for Healing Justice, and it's something I've kind of gone heads up with Healing Justice about, because at least from what I recall anyway, their kind of theory is you should notify anyone anytime you open a case. Because most of our cases end up with nothing being done in them. I just don't ascribe to that. I don't want to do that to people. I just don't want to call up a murder victim's family and say, we're looking at this case, if I don't even have any idea at that point whether or not it's a case that looks like it's heading to a recommendation for relief.
And if I may, Guy, you're kind of look like you're nodding in agreement on that from the victim's rights perspective. What do you think about that in terms of not notification that an outcome is coming, but just that there's an investigation that's going on?
No, I mean, and not to give the lawyer answer that it is a case by case basis, but here's, I think, the global rule. It's sort of my number one, sort of, if I was giving my top 10 rules for this, and I literally have it as number one, is early and direct notification. But what does it mean to be early and direct? To Val's point, because there's some other rules, so to speak, that I have. If you call a family, so I know Healing Justice has done a lot of amazing things, and I'm not taking issue with them. But if you call a family of a murder victim and say, we opened up a potential review of the defendant or the convicted individual's case that murdered your son, for instance, you're going to, well, what do you mean? Why? What evidence do you have? How long is this going to take? What's the process? Oh my God, there's going to be 50 questions, and how many of them are you going to be able to answer? 2, right? Because you don't know. And so for at least I have worked with, without exaggeration, and I mean this, and this is not even, well over 10,000 victims in my 16 years of law practice. And so my 10 rules are all based off of the collective experience. And when you hit 10,000 plus, I don't think it's anecdotal anymore. And so are there going to be families who say, I cannot believe you didn't tell me when you opened this case file up? Of course. Do I strongly believe, based on experience, that the overwhelming majority will not want that notification unless there is actually going to be action taken in some capacity? That's where I think it comes. So early and direct relates to once you've really made a decision, or you're on the precipice of making that decision, because you're still going to have it's going to be time before you have to go to court, or at least once you've gathered enough evidence to at least give you the inkling of where this is going. That is when notification needs to be made, from my perspective, right?
I think that the balance there is, and we've all seen this happen, that when a decision is pending, things can move very, very quickly.
It can.
And so it's trying to reach that balance between the early and direct notification and certainty that Val's talking about. Do you have recommendations, and I'm going to stick with you, Guy, before moving back to Val? Yeah. Do you have kind of recommendations for either? Defense doesn't want to slow that down because obviously they want their client to get out as quickly as possible. How do you help? What advice do you have to folks kind of help strike that balance?
Yeah. So my advice would be this. So, and Val sort of touched on it a little bit. You have a frontline prosecutor obviously reviewing. I think in most cases, of course, at times there may be the actual elected DA, but I think for most cases, you're going to have a frontline or a deputy or chief, whatever individual's jurisdiction calls it, working up the case and deciding whether or not to make a recommendation. If based upon that review, and then ultimately it's the elected DAs in most jurisdictions then position whether or not to agree or disagree with the relief that's being sought. That's when, meaning if you are the prosecutor who's going to the DA and saying, look, if we don't do this based upon this evidence, I mean, we are letting an innocent man or woman sit in jail, or based upon this, it's unequivocal that the prior prosecutor, you know, was out of line, out of bounds, where this trial didn't pass, right? Violated Brady, you know, depending on your jury, Goodwill, right? So at that point, you're making a strong recommendation that's evidence-based, right? Not feelings-based, not emotions-based, evidence-based. And if you're making that recommendation, that's when, and so now the prosecutor has time, the elected DA has time to make the decision. And in that process, that elected official or the front line, depending on how you choose it, can bring the family in before it's notified to the defense, to your point, Marissa, before, of course, they're going to want, they get that relief that's agreed upon, they're going to want it done tomorrow, right? No doubt about it. So before that's given, have that notification with the family and tell them the process.
But
And
so,
there's-
Marissa, let me jump in here. I think you can work, for those of you in prosecutors' offices, I think you can work with the defense. So we just had a case, a gentleman where we granted relief. He got out, I think, 3 weeks ago. All right. And I talked with the defense attorney and I said, this victim is very upset. I've met with her multiple times already, and I think it's in your client's best interest to give me another week or two to keep working with her and build up some trust. She wants to meet with the elected prosecutor. The elected prosecutor is willing to work with her, but to fit in that meeting on the elected prosecutor schedule is going to take me some time. And I don't want this to get derailed in the courtroom. And so one thing I think you can do as a prosecutor is just be honest with the defense team. And it doesn't make sense to push forward to move things so quickly. Like I said, a minute in prison when you're innocent is a minute too long. I get that. I was a defense attorney for 23 years. When I started this job, I wanted people out yesterday as soon as the prosecutor made a decision. And I was very frustrated by the time it would take to do victim notification and do other things that were required of me to do. But I will tell you with experience, and I have a lot of experience. I mean, this unit has granted relief, I think, in more cases than most units. I mean, we've done this 42 times at this point. Again, I don't have 10,000 plus touches like Guy does, but I think I have a lot of experience in terms of what's going on. And it works in everyone's best interest if you just sometimes slow things down and do it properly. In the Levon Hill case, we worked with the defense attorney and we got the time that we needed. And it really worked out to everyone's benefit, because in court at the hearing, the victim actually said that she was so unsure and she thought he was guilty, but she had thought about everything, listened to what everyone said in court, and now she thought he didn't do it and deserved to get out. That's a huge turnaround from someone who was crying at every single time I met with her. And just would not listen to anything I had to, nothing I said registered. Giving her the facts, giving her the investigation, working with a victim's advocate. I mean, every single thing I did to help her, nothing was helping, but it was the time and the repetition and the meeting with the elected prosecutor who she trusted, because she did not trust me. That really made a significant difference. And I think made the difference between a proceeding that was procedurally potentially going to get derailed in court at the moment we were waiting for a decision from the judge, and something that proceeded very smoothly in court, and where so the gentleman got out, the order got signed, everything got done, and the victim was really was in a place where she could hear and accept what was going on. So I know there's several questions, Marissa. I don't know if you want
Yeah, I just kind of going back to the question that we had before about, like, when do you start working with victims? And so and there are folks who are commenting in the chats that they do the notification when they're going out to conduct an investigation. And I will say that many CIUs in particular, the reason that they do that is because they don't want word getting back to the victim because they're out talking to people in the neighborhood or they're doing other things, and they want to be ahead of that. So I think this kind of goes back to what both of you are saying, that it's a case by case determination. But if you're doing investigation out in the field where there's talk, that maybe that's a good point to do that, as opposed to DNA testing or something else, which doesn't involve community.
Exactly.
Right.
Exactly.
And again, I think it depends on the case. There are cases where not in the same, whatever the new evidence is, you can be fairly certain that it's not going to be, people are talking about it. In which case I wouldn't do the victim notification at that point. I'm guessing everyone in a CIU has a very similar experience to me, which is a lot of cases you fully investigate and you say no, right? You find either more incriminating evidence or the new evidence collapses or whatever happens. It's not an investigation that's going to go to the elected prosecutor with a recommendation for relief. And so again, I think it depends on what is the investigation, right? Like I just talked before this call, I just talked to someone who made a tip in a case. I don't feel the need to talk to the victim's family in this case, to talk to someone who phoned in a tip. I just needed more information to see if the tip was true and if he really said what they say he said, because he never testified. So, I mean, there's an example where I would not call the victim's family before I talk to this person. So I really think people have to think long and hard about it. And in fact, when I talked to him, he confirmed that the person in fact made incriminating statements and that he was available to testify and had been in court, but the prosecutor just hadn't called him. So he said a lot of confirming things that are going to be, that are going to negatively impact, at least at this point,
Right.
the investigation into the innocence claim. And why am I going to call this family where this man was brutally tied up and murdered and set on fire? And, it's a horrible fact case. So I don't want to call that family right now. And I don't feel like I need to based on that particular path of investigation.
And Guy, again, you seem in agreement with Val on that.
Yeah, and so this isn't even about a perpetrator getting out, what I'm about to share. So on the civil side, my firm does a couple of things, but my team exclusively represents survivors of sexual, physical violence, bullying, and hazing. I share that to say this. I can count on one hand how many clients out of the hundreds now that I have represented over my civil career, where this happens. Client will say in the beginning of the case, in the civil case, right? So we're not even dealing with the stakes of the actual rapist or person who perpetrated against them. It's the institution that let it happen, right? Okay. Where they'll say, I want every update. Like, I don't care small or big. I want you to tell me everything. I can count now on one hand how many clients within a month go, I still want that. Meaning less than 5 in my career have still maintained wanting that. Meaning everyone else is like, I know I said I wanted all of those notifications, but like, can you stop doing that? Because it is so triggering and trauma. Because like, when I hear from you, like this, like you told me about a motion to compel. I don't really understand what that means. And I get it as an email at work and I spiral. And then I talk to you at 7 when I get done from work and you're like, oh, this is routine. I thought I put that in the email, but you did, but I got scared. Meaning, like, unless it's actually going to impact my case, right? Or like there's a really good positive update. Like, let's just keep those notifications to a minimum because it's trauma and it's triggering when I get those notifications. Meaning, I truly believe survivors and victims of crime, this is not a one fits all, right? It's not cookie cutter, but for the vast majority, it's, I want information that's digestible and actually is something that I can understand and process. And you can't understand and process it if you, as the person delivering the message, like I said in the very beginning, can't answer very basic questions because you yourself don't know yet.
There. And there's a question in the chat about that notification. So obviously we're talking about post-conviction investigations. And in some jurisdictions, it's not possible, but sometimes the defense will have or wants to contact the victim before the CIU has started their investigation. Are there kind of best practices or suggestions to be able to make to prosecutors who are in that position, like where they've been notified, where the defense either has or wants to reach out to the victim? Are there suggestions that you might have, and kind of looking at you, Guy, first, in terms of how to either manage that conversation with defense counsel or how to handle that notification? Like, do you run ahead and kind of say, okay, victim, you might be getting this call, or are there other ways to be able to handle that professionally?
Sure. I mean, so when I was a prosecutor, I would deal with that all the time. A defense attorney in a non-post conviction setting, right, where a defense attorney, despite and look, and I was a prosecutor's prosecutor, right? So I mean,
Yes, he was. I can verify that. Like,
yeah. So, but I'm not. I mean, I'm a Democrat, but I'm not coming from a liberal place when it comes to crime and punishment. But I share that to say this: despite some of my brethren and sistren who believe that a defense attorney doesn't have a right to speak to a victim during the pendency of a case, it's like I'd have to disabuse them that it's not actually, they're not our clients, right? The Commonwealth in Pennsylvania is our client. And anyway, I share that to say this, but when a defense was like, I want to speak to the victim, it's like, okay, well, the victim doesn't have to speak to you, but I can potentially facilitate that conversation, and I may be willing to do so. Why? Right? And not an accusatory why, but what's the outcome you're looking for? Because if it's to scare, threaten, or do something else, then no, I'm going to tell them, look, it's your right, but you don't have to talk to them, and here's what they're probably going to do when they do. And also, you can also request to have me there or refuse to talk to them if you don't want to. But if, I've had defense attorneys say, I want to talk to them to get a better, and the ones I trusted, I want to get a better understanding. I mean, they were in the best position to see X, Y, or Z. And the ones who were truly doing I need to represent my client, but I need a better understanding. Yeah, sit in and listen if you want. Like, what do I have to hide? I'm not going to say anything untoward. And so I think that goes a long way. I think a prosecutor can offer that, right? Like that you're going to hear things from a defense attorney in court if you show up for the post-conviction hearing, and that defense attorney is willing to talk to you about what they're saying and why they're going to say it. And I think that potentially could go a long way. And if the victim or the victim's family is willing to have that conversation, I think that shows that the victim's family or the victim themselves, if it's not a homicide, is truly receptive to the truth, or to at least hearing someone out evidence-based, right? And I get it. I understand anyone who's ever been victimized by crime or who has had a family member. Sometimes I don't care what the evidence is. You're saying this person did this and they're convicted, then that person's going to forever sit in jail, right? I don't care what evidence you have. I'm not knocking those people from an emotional mental health perspective. Maybe that's where they're at, and I can't judge someone's trauma. But that person, yeah, they're not going to hear out a defense attorney, and there's probably going to be a lot of colorful language exchange, and that's being polite, right? But you getting that feel from the victim survivor, if it's someone who it's not a homicide, I think will show you and will go a long way in the healing process and the understanding process. And at the end of the day, it's not that the victim survivor or just the victim's family is going to necessarily agree with whatever position you took. It's not. Every victim I've ever talked to is like, I just wish I had been informed along the way with clear, concise transparency, right? They want transparency, the good, the bad, or the ugly, right? They don't want the answer that they want to hear. They want to have clear, concise, transparent language. And if you're not able to do that as a prosecutor, and this might sound harsh or blunt, then you're in the wrong business, right? Go do something else, right? When I sue Child Protective Services and they tell me I couldn't do X, Y, or Z because I'm too busy, I don't give a shit, right? Like, then don't do that job. Go do something else if you can't do the very thing that you have to do, which is work with victim survivors.
So Marissa, can I just
But-
follow up? So
Yeah, and then I have a
couple of things
question for
about
you.
that. Yeah, one, I have had victims reach out to me because the defense has reached out to them. And then I just let them know that, I mean, usually we're not even investigating the case yet, so I know nothing. I really don't have anything to offer because I haven't even looked at it. But all I can do is I do what Guy is suggesting we all do, which is I'm honest. Like, this person has applied to our unit. They have such and such as their defense attorney. They're allowed to reach out to you. You don't have to talk to them if you don't want to. You can tell them you don't want to talk to them. You can talk to them, whatever. I mean, it's totally your choice. But, we'll keep you informed if anything develops in terms of the investigation. And I know, again, there's so many variations among CIUs across the country. There's people on here where, your defense attorneys, and if you have a CIU that you trust and you can work with, and there's defense attorneys on here, like, I would never in a million years trust anyone at our prosecutor's office. So I understand the variations. I would just say, as a CIU director, I try very hard to convey to people to please not reach out to any witness, let alone a victim, if they're going to apply to the CIU without at least touching base with me, so I can do exactly what Guy said. Like, talk to them. Why do you think you need to talk to this person? What is it that you're trying to get? And can we just facilitate something to make it easier for this person? So if you have that kind of trusting relationship, you know, as a defense attorney, I suggest you reach out. If you don't have that kind of trusting relationship, I guess you got to figure out that, you know, you got to figure out what you got to do. You have to represent your client. But I don't know that talking to the victim is always a good first step. And it certainly stirs the pot in a way that can cause a lot of problems. So I'm not really, if I was a defense attorney, I would not be talking to a victim unless it was something that I absolutely needed to do, because there was no other way to investigate the case without starting with the victim.
Right. And I think, Val, I think you've actually already kind of addressed my next question for you with the case that you were referring, but is when you've had cases where the victim is being kind of vocal about their opposition to any relief whatsoever from your office, or is objecting to a particular resolution, how have you handled that?
Well, I think all you can do is treat people the way you would want to be treated. So I just try and put myself in their shoes. I remember one case where it was a firebombing, and this mother lost 2 young children in this house fire, and she was irate. I mean, just absolutely irate, and her son was the star witness. So the fact that we were granting relief caused multiple levels of trauma for her. It meant we didn't trust her son's testimony. You know, it meant that her 2 children who died in this house fire, you know, the case, no one was being held responsible. And you just have to have a lot of patience and kindness in your heart for people who are in an emotional place where they can't listen to reason and they can't hear you. That woman was never going to hear me.
Right.
But I listened and I was compassionate. I warned the judge ahead of time. I told the judge before we went into court that she was irate, did not agree with the granting of relief, that we had had multiple conversations with her, trying to explain everything to her, but that I expected the hearing was going to be very volatile. And it was. But the judge was prepared. And so he knew ahead of time. He also knew ahead of time that I had multiple meetings and had explained things, and had to, you know, tried to get her to work with a victim's advocate, offered assistance, you know, did everything that I could to help her out. So I think that's one thing. And again, I say all this understanding judges are different. Not everyone can approach their judges. Not every judge is helpful and kind and engaged. So the things that have worked for me may not work for you. I just encourage people to think creatively. Like, don't let yourself get boxed in. Victims are human beings who have suffered, in most of our cases, suffered a horrendous tragedy. And we have to find a way to be kind and compassionate, while at the same time making sure a person who we have discovered through our investigations, or the defense believes through, you know, also through their investigation, it didn't commit the crime, is not harmed further by anything that's going on. And I also will say that I warn defense attorneys if there's going to be volatility from the victim, so that they can let their client know and they can prepare their client for what might happen in court. Because I don't want to see any wrongfully convicted person, you know, sitting there thinking, this is my big moment. Finally, people are going to hear me and I'm going to get some justice. And then they get this vitriol directed at them from the victim or the victim's family. So I just think it's important on all levels to remember that we share information We let everyone know what's going on. And as much as possible, that the prosecutor's office works with the defense attorneys to make the proceeding the best it can be for the wrongfully convicted person, and for the victims.
And Guy, I think, so we had planned, so everybody knows, to kind of have breakout rooms to have these discussions a little bit more granularly with folks. So we're going to be doing that in just a few minutes with Guy, Val, and myself each heading out a breakout room. But so Guy, before we get to that though, can you just give us an understanding of what happens with victims and their families when they're not informed of a resolution? What steps can they take, either under the law or that you've seen kind of on a more creative side of ways that that victims can try to express themselves or even insert themselves into a post-conviction proceeding?
Yeah, I mean, I know Val was talking a couple of questions ago about, understandably so, if it's a wrongfully convicted individual, that the defense attorney wants the person out yesterday. No, the person sitting in jail certainly wants to be out yesterday, right? Here's the problem with that, right? If a defense attorney or anyone says, well, you need 3 to 4 weeks to talk to this victim, I have an innocent man sitting in jail. Okay, well, here's what's going to happen if this victim is not notified. And this is not anecdotal. I've done this, right? A family was notified the night before and agreed upon relief. This is one example. I have a ton that I can share, but a family was notified the night before at like 6 p.m. for a post-conviction relief hearing, where it's told by the prosecutor. I was told by the prosecutor that there was a routine hearing tomorrow morning. You're more than welcome to come at 6 p.m. The hearing's at 9 a.m. But you don't have to, right? Okay. She's confused. She hasn't been reached out to in years, didn't really know the process was happening. Anyway, she starts making calls. I get a call because someone's like, look, this is what this woman was just told, like literally a couple hours ago. This is now like 8:30 p.m. Can you do something tomorrow? So we immediately wrote all throughout the night a petition for extraordinary relief to enter into the case, because we learned that this was not a routine hearing. In fact, this was the granting of relief. Now, my position in what I filed wasn't that this defendant was or wasn't entitled to relief. I didn't touch on that, right? So what does that mean? This person could very well have been innocent, and I'm not suggesting he was or wasn't at this point, because that wasn't my role, right? My role was, here's what happened with this victim, right? And they have no idea what's actually taking place tomorrow. They were afforded no opportunity. They were shown no evidence whatsoever. They were just told, hey, we're just letting you know there's a hearing tomorrow. Anyway, I filed that. So for someone who's worried about 2 to 3 week delay in making sure this is done right, well, 18 months later, and I'm not exaggerating, like it still wasn't resolved for something that was agreed upon between the prosecutor's office and the district attorney and the defense attorney, because of that notification. And it opened a can of worms, because here's why it opens a can of worms. My first question was, and look, I take the victim role representing victims, right? But I don't lose sight of the fact that in the wake of this, there is a potential defendant who's innocent sitting while there's now this fight going on, right? So it's not just a lack of notification. Now, all of a sudden I go, well, hang on. How long have you been working on this post-conviction relief? Well, 1.5 years. When did you make the decision that you were going to grant this? 6 months ago. And you notified the victim less than 8 hours, 10 hours before the hearing? What does that tell me? There's something I don't believe this, right? And that's what happens. I don't believe this man's innocent. I don't believe he was wrongly convicted. I think there's something untoward going on, because if you had actual evidence that this person was either wrongfully convicted or innocent, why would you bring the victim in and sit them down 6 months ago, 5 months ago, 4 months ago, 3 months ago, right? The fact that you didn't, and the fact that you told this person, and they never said they didn't tell them this, the fact that you told them it's a routine hearing tells me there's something more going on here, whether that's accurate or not, right? But that's the impression it gives, and that's why it takes so long. And now you're opening up a whole new legal battle that may not have been necessary if someone just did the very basic, necessary, and right thing.
Okay, fair. So we are going to open up breakout rooms now to kind of give folks a chance to have these conversations together. Well, again, what we're trying to do is really come up with some guidelines, checklists, materials that are helpful for prosecutors and defense lawyers to try to avoid these kinds of issues from arising in court, avoiding the blow-ups, as Val said, or the potential intervention of somebody like Guy coming in to do to do that. So I'm going to go ahead and open up the breakout rooms. I'm going to let people choose, but I'm going to ask, I'm going to put Val, you're in room 1, Guy, you're in room 2, and I'll probably be in the least popular room, which is room 3. So I'm going to open those up now and then ask folks to go ahead and just put yourself into a room. We're going to keep those open. It's 2:53. We'll keep them open for about 10 minutes so we can come back together again at the end just to kind of share a bit as well as talk about next month's meeting. So please go ahead and put yourself into a room. And I will put folks into a room if you don't do so. So Val and Guy, please go to your designated rooms and everybody else will see you in there. I'm going to apologize to Beth Morrow because she was in the middle of saying something very, no doubt, profound when we all just got kicked back in here. So if that happened to anybody else, I do apologize. But I wanted to kind of give us some time back together in this space to kind of just wrap up, as well as a little bit of looking forward to the future. So Val, you're the one who's in my space right now. If you could report a little bit back about any.
Absolutely. I think we had a great discussion, and I think there's a lot of room for more discussion on this topic. So I want to, first of all, thank you for doing this and thank everyone who's here and participating. So we kind of broke it down into, when do you want to notify, which is going to be, I think, as we discussed, case by case. Who's going to do the notification? Is it people from the CIU unit? Is it a victim advocate? Is it both? How are you going to do the notifications? Are you doing them in person? Are you doing it on phone? Are you setting up a Zoom call? Like, how are you doing this and how are you making that approach? And then we talked about Colorado and Massachusetts, where they talked about how victim notification is mandated before you even start DNA testing. So, those kinds of mandates are going to affect, you might not want to notify the victim at that point because there's nothing to say. But obviously, if you're mandated to do it, you don't have a whole lot of choice. So how to handle those kinds of notifications, which are different because you don't have a lot to share with someone other than we want to do this testing because this person is maintaining their innocence, but we don't have much more to say to you because we haven't done it yet. And then the last thing that was brought up that I think is really important and we haven't touched on at all is notification to critical witnesses. So there's sometimes people who testify in a gang trial or testify at great, personal sacrifice potentially from what might happen to them, and making sure, and they're not victims, but making sure that we keep an eye out for those people as well in terms of notifying them of what's going on and that something has changed and what it is that changed so they can be aware.
Great. Guy, your thoughts from your group?
Yeah, so I sort of went over what I consider, and this is based upon my time as a prosecutor. And Marissa, after we spoke, I haven't even shared this with you. I reached out to clients of mine who are rape survivors with this top 10 list to see if this is something that they would want. As many of them have their perpetrator was been arrested and in his jail, and this is got their feedback. And so I went over the top 10, I think, best practices in terms of engaging and working with victims and survivors. And so we talked that through, all 10 of my sort of top hits, and then why I feel that way and what those mean to me. And then there was a question of like, okay, there was a great question from one of the members of the group. Who do you decide if you're making that outreach, if it is a homicide, how do you decide, or who do you decide to reach out to? What if there's a division in the family?
Right.
And, my answer in terms of best practice to that, if the prosecutor who originally tried the case, and assuming the prosecutor's, is in good standing, and maybe hopefully ideally it's not because the prosecutor did something he or she shouldn't have done. But even if that is the case, if you can get from them or someone else who was in the room, who from the family was present for this trial, who spoke, if you don't have the transcripts, or you should have, right? Identifying those people, and that's who I would first go to. Then I shared sort of anecdotally who I would go to next if I don't know the answer to that is, and this is Pennsylvania, but this is, I think, is pretty symbolic, not symbolic. I think it's based across the country. 90+% of murder victims are men. And so the reason I share that, and again, this is my own biases, like I'm a mama's boy. So like, if I don't know otherwise, I'm reaching out to the mom, right? Like that's who I'm trying. I might get that wrong, but that's who I'm going to reach out to first.
Right. Mm-hmm. So we want to thank everybody, of course, for participating, especially Guy and Val, for taking the time to meet with us. As I've said at the top, what we're really trying to look for is developing some of those resources. Guy and Val have both, whether they're aware of it or not, volunteered to help us put that together and write that. If you are interested in in helping to put that resource together for prosecutors, for innocence lawyers, of issues to be aware of on notification of victims for agreed upon outcomes, please let me know. You can just contact me directly, or even just raise your hand here, and we'll be happy to have you be a part of that, because we do want to have something produced for folks that you can use and go to and use as a kind of go-to. But please, everybody, join me in thanking Guy and Val for the time, and everybody else for your participation here today. And just as a preview for next month, we will have, as usual, our training will be on the second Wednesday of the month from 2 to 3:15 p.m. Next month, the topic will be evaluating cases of shaken baby syndrome or abusive head trauma with Mark Freeman, who is a nationally known defense lawyer in these issues, as well as Sunny Eaton, who is the director of the Nashville, Tennessee CRU, who handled a very complex case involving that earlier this year. So please, we hope to see you all then. In the meantime, of course, if there's anything that we can do to be helping you, please let us know. But again, just thank you so much for Guy and for Val. Very grateful for your time and expertise. And thank you, everybody else. We hope you have a wonderful holiday season.
Thank you all.
Thank you. Bye.